engineering.
A transactional attorney needs an answer. Under Delaware law, can a board of directors adopt a shareholder rights plan without shareholder approval? And what standard of judicial review applies? Traditional research. An associate spends 4 to 8 hours on Westlaw or Lexis, reading cases, checking subsequent history, analyzing holdings, drafting a memorandum. The quality depends entirely on the associate's research skill, familiarity with the practice area, and available time. Off-the-shelf AI research tools produce answers in minutes, but with a fundamental reliability problem. The model generates citations that look real but may not exist. It summarizes holdings that sound plausible but may be fabricated. It conflates standards from different jurisdictions. The attorney must verify everything, and if you must verify everything anyway, the time savings evaporate. What if the research system deployed specialized AI agents, each performing a focused task in parallel, with a verification layer that confirms every cited authority actually exists, is still good law, and actually says what the research claims it says? Multi-agent legal research separates these functions into specialized, verifiable steps. An AI question decomposition agent breaks the research question into discrete sub-questions. An AI authority identification agent identifies relevant statutes, case law, and secondary sources for each sub-question. Searching legal databases, not training data. An AI authority verification agent confirms every citation. The case exists. It has not been overruled. The holding actually appears in the source. An AI counter-authority agent searches for authority that cuts against the analysis. And an AI synthesis agent constructs the final memorandum with verified citations, counter-authority discussion, and confidence assessment. No citation reaches the memo without verification. A concrete example. A corporate attorney needs to know, under current Delaware law, what are the fiduciary duty implications for directors who approve an AI-related transaction where board members have personal investments in the AI vendor? The system decomposes this into 5 sub-questions. From the standard of review under DGCL Section 144 to whether recent case law addresses AI-specific fiduciary considerations. For each sub-question, the AI authority identification agent retrieves real citations from real sources. DGCL Section 144, Weinberger v. UOP, the foundational entire fairness case. Con v. M&F Worldwide, the MFW cleansing framework. Benihana of Tokyo versus Benihana, interested director transactions. Recent Chancery decisions analyzing materiality thresholds for director financial interests. Every citation passes through the AI verification layer. Does the case exist? Has it been overruled? Does the holding actually say what the research claims? Weinberger v. UOP, confirmed, still good law, foundational. Con v. MFW, confirmed, established the dual protection framework. Every authority verified against the actual source before it reaches the memorandum. This is the hallucination elimination layer. No fabricated citations, no mischaracterized holdings, no repealed statutes cited as current law. The verification checkpoint is the architectural difference between AI research you can rely on and AI research you must independently verify. The AI counter-authority agent actively searches for authority that cuts against the preliminary analysis. Cases where courts found director interests immaterial. Cases where business judgment was restored through proper cleansing procedures. Every research memorandum includes contrary authority. No one-sided advocacy masquerading as objective research. What takes an associate 4 to 8 hours? The research, the reading, the verification, the drafting, the multi-agent architecture completes in minutes, with every citation verified, every holding confirmed, every counter-authority surfaced, from question to verified memorandum, not a chat response, a research document a senior attorney can rely on. When you subscribe to an off-the-shelf AI research tool, you get speed but not reliability. You get citations but not verified citations. The research model was not built for your jurisdiction, your practice area, or your quality standards. And the attorney must verify everything independently. When Taylor Legal Engineering builds a research workflow for your practice, you get verified research, every citation confirmed, every holding validated, calibrated to your jurisdiction, your courts, your controlling authority. Jurisdictional calibration, practice area specialization, source priority configuration, your standards, your infrastructure. Off-the-shelf research tools are a rental. What Taylor Legal Engineering builds is research infrastructure you own. Verified, human-controlled, jurisdiction-specific, counter-authority aware, integrated with your systems. You own the research models. You own the verification logic. You own the data. This was episode 10, Legal Research. This concludes the series. 10 episodes, 10 workflows. 1. Architectural philosophy, specialized AI agents, parallel execution, human control, custom configuration, permanent ownership. Every engagement, assessment, design, build, handoff, fixed scope, fixed price, you own the deliverables. 10 episodes, 10 workflows. 1. Architectural philosophy, Taylor Legal Engineering. We don't sell legal AI tools. We build legal AI infrastructure. Every workflow, every practice area. Let's talk about what we can build for your team.